Welcome to LexTalks, legal topics. Simplified a space for, well, simplifying legal concepts. We love to do that here. And today we're going to be diving deep into the world of leases, a
Yes.
topic that's incredibly relevant here in India. I mean, whether you are a future property lawyer or just navigating the rental market yourself, understanding leases
Yeah.
is crucial.
Yeah. And what's so fascinating about leases is they really touch upon so many aspects of our lives, right?
Yeah.
From housing to agriculture to business. You might be surprised to know that in India, a staggering 99% of farmers
Wow.
operate under lease agreements, mostly for agricultural land. So that's a huge part of our economy.
That's a statistic I was not aware of,
Yeah.
99%. That really highlights how leases are so woven into the fabric of our society.
Absolutely.
Okay, so let's start with the basics.
Okay.
What exactly is a lease in legal terms?
So a lease, in simple terms, is a contract where the owner of a property known as the lessor grants another party, the lessee, the right to use and enjoy that property for a specific period. The key here is it's about transferring the right to use, not ownership.
Okay, so it's about having access to and using the property, not actually owning it.
Right.
That's a fundamental distinction.
It is.
But what makes a lease legally valid? What are those non-negotiable elements?
You're right, those distinctions are key, especially for you as future lawyers. To be valid, a lease must have certain essential elements.
Okay.
So firstly, you need competent parties, individuals who are legally capable of entering into a contract.
Right, so we can't have someone signing a lease who isn't legally capable of understanding the agreement.
Exactly.
Right.
So the property itself needs to be clearly identified. The lease agreement can't be vague about what is being leased out.
Yeah.
Then, of course, the lease must grant the lessee the right to enjoy the property, to actually use it for its intended purpose.
That makes sense. You need to know exactly what property you're dealing with and what you're allowed to do with it. What about the duration and the cost?
Absolutely. The lease must specify a clear time period, whether it's 6 months, a year, or even longer. And it must state the consideration. This is typically rent, but it could also be a premium paid upfront.
Okay, so we've got the who, the what, the how long, and the how much.
Yes.
What else do we need to make this a legally binding lease?
2 more key things. The lessee needs to formally accept the terms of the lease signifying their agreement. And finally, the lease should address the issue of transferability, whether the lessee can sublet the property or assign the lease to someone else.
Got it. So those are the essential ingredients of a valid lease.
Yes.
But I imagine there's a lot of variety in how these details are spelled out.
Absolutely.
That's where the different types of leases come in, right?
Exactly. Just like we have different types of contracts, we have different types of leases, each tailored to specific situations and needs. So let's explore some of the most common types that you'll encounter in India.
Okay. Let's break down these lease variations. Hit me with the first type.
Okay. Let's start with the absolute net lease. Imagine you're a big company renting an entire office building. In an absolute net lease, you, as the tenant, would cover all the expenses associated with that property.
All the expenses.
All the expenses.
So maybe it's insurance, property taxes, maintenance, everything.
Everything. You got it. It's like being a homeowner without actually owning the property.
Wow.
It's a significant responsibility, but it also gives the tenant a lot of control over the property and its upkeep.
Okay, I can see how that would appeal to a large business that has the resources to manage all those aspects.
Right.
What's the next lease type on our list?
Next up is the triple net lease, which is very similar to the absolute net lease.
Okay.
In this case, the tenant is specifically responsible for 3 key expenses:
Okay.
property taxes, insurance, and maintenance.
Okay, so it's like a slightly lighter version of the absolute net lease, but those 3 big expenses are still on the tenant's plate.
Precisely. Now let's move on to a type that offers a bit more flexibility:
Okay.
the modified gross lease.
Okay.
This one is very popular because it allows for a more customized arrangement between the landlord and tenant.
I'm sensing a theme here. Leases are all about balancing control and responsibility between the two parties.
You're absolutely right. In a modified gross lease, some expenses are shared while others are the sole responsibility of one party.
Okay.
For example, the tenant might pay base rent plus a portion of the operating costs,
Okay.
while the landlord covers structural repairs.
Okay. So there's more room for negotiation and tailoring the lease to specific needs. I bet this type is quite common,
It is
especially for smaller businesses or individuals.
very common. And finally, we have the full service lease.
Okay.
This one's often found in large multi-tenant buildings, like office complexes or shopping malls.
Full service sounds pretty appealing for the tenant.
It does.
Does that mean the landlord covers pretty much everything?
It does. In a
Yeah.
full-service lease, the landlord typically handles most of the operating expenses, including utilities, common area maintenance, and even property taxes.
Wow. So the tenant essentially just pays their rent and enjoys a hassle-free experience.
Yeah.
But I imagine that convenience comes at a price.
You're sharp. The rent in a full-service lease is usually higher to cover those additional costs that the landlord is absorbing.
Right.
It's all about finding the balance that works best for both sides.
That makes sense. It's a trade-off between control and convenience.
Right.
So we've covered the basics of what a lease is and the different types you might encounter. But what about the legal nitty-gritty? What are the rights and liabilities of the landlord, the lessor?
That's where things get really interesting, especially for you future legal eagles. Let's dive into the world of rights and responsibilities.
Okay, I'm ready. Let's explore the legal landscape of leases.
Okay, welcome back to LexTalks. Now that we've got a grasp on the types of leases out there, let's zoom in on the rights and liabilities of the landlord, or as the legal term goes, the lessor.
Okay, yes. Let's untangle those legal threads.
Yeah.
It's super important to understand what each party is entitled to and responsible for in a lease agreement. So where do we start?
Well, the lessor's rights, they flow directly from the lease agreement.
Right.
They have the right to receive rent as agreed upon.
Right.
That's like the foundation of the arrangement.
Makes sense.
They also have the right to regain possession of the property once the lease term ends.
Okay, that makes sense. The property is theirs after all, so they should have the right to get it back once the agreement has run its course. But what about, like, enforcing the rules of the lease itself?
That's another key, right, of the lessor.
Okay.
They can enforce the terms that are laid out in the lease.
Okay.
So think about things like restrictions on subletting the number of occupants allowed, or even pet policies.
So it's not just about collecting rent. They have a legal right to ensure the terms of the lease are upheld.
Right.
But I imagine that also comes with certain responsibilities, right?
Absolutely. The lessor has some pretty crucial obligations, too.
Yeah.
One of the most important is the duty to disclose any material defects in the property.
Okay.
Think about things like a leaky roof, faulty plumbing, or any structural issues that might not be obvious to a potential tenant.
So the landlord can't just sweep problems under the rug and hope for the best. They're legally obligated to be upfront about those issues.
Precisely. Hiding those kinds of problems can lead to legal trouble down the line, especially if it affects the habitability of the property or poses a risk to the tenant. Transparency is key.
Yeah, that makes sense. It's about ensuring a fair and safe environment for the tenant. What other responsibilities does the landlord have?
Well, another key one is ensuring the tenant's quiet enjoyment of the property.
Okay.
And this means the tenant should be able to use and enjoy the property without undue interference or disturbance from the landlord.
So the landlord can't just barge in whenever they want or throw loud parties next door. The tenant has a right to peace and quiet within their leased space.
Exactly. The tenant is paying for the right to use and enjoy the property, and that includes a reasonable expectation of privacy and peaceful living. Now, let's flip the coin and examine the tenant side of things, the lessee's rights and responsibilities.
Yes, it's all about balance, right?
Yeah.
Both parties have certain entitlements and obligations under the lease agreement. What rights does the lessee have?
So the lessee or tenant holds the exclusive right to possess and use the property for the duration of the lease.
Okay.
This means they have the right to occupy the space, use it for its intended purpose, and generally enjoy the benefits of living or working there.
Okay, that seems fair. They're essentially paying for that exclusive right to occupy the space.
Right.
But what about subletting or assigning the lease? Is that an automatic right for every tenant?
That's a great question, and it's one that often causes confusion.
Yeah.
The right to sublet or assign the lease depends entirely on what the lease agreement says.
Okay.
If the agreement explicitly allows it, then the lessee has that right.
Okay.
But if it's prohibited or silent on the matter, the lessee would need the landlord's consent.
So reading the fine print is crucial. I imagine subletting without permission could lead to trouble.
It certainly could. It's a breach of contract, and the landlord might have grounds to terminate the lease or pursue other legal remedies.
Makes sense. So it's important to be clear on those terms from the outset.
Huh.
Now, what about the lessee's financial obligations? What are their key liabilities?
Well, the most fundamental liability of the lessee is to pay rent on time and in the manner specified in the lease agreement. That's the cornerstone of the whole arrangement.
Right. That's a given. But beyond the rent, are there other responsibilities the tenant has to the property itself?
Absolutely. The lessee has a duty to maintain the property in good condition, reasonable wear and tear excluded.
Okay.
This means taking care of the space, addressing minor repairs, and essentially acting as a responsible occupant.
Okay, so normal wear and tear is to be expected. Things get a little worn over time with regular use, but if they damage the property beyond that, they're liable.
Exactly. If they punch a hole in the wall, damage appliances due to negligence, or cause significant damage beyond normal wear and tear, they would be responsible for the cost of repair.
So it's about being a good steward of the property even though you don't own it. What about communication with the landlord? Does the tenant have any obligations in that regard?
Yes, communication is key. If there's any damage to the property, or even if there's an encroachment issue, the lessee is obligated to inform the landlord promptly. They can't just ignore problems and hope they go away.
So it's a two-way street. The landlord has a duty to disclose pre-existing problems, and the tenant has a duty to report new problems that arise. Makes sense.
It does. And finally, when the lease term comes to an end, the lessee is responsible for returning the property to the landlord in a reasonable condition.
Okay.
This means cleaning the space, removing personal belongings, and essentially leaving it in a similar state to how they received it, minus normal wear and tear.
It's about handing back the keys in a responsible manner. So we've covered the core rights and liabilities of both the lessor and the lessee.
Right.
But I imagine things aren't always so straightforward in real life.
Right.
What happens when a lease comes to an end?
That's where things can get a bit more nuanced. Let's delve into how leases are determined and what happens when a lease expires.
Okay, I'm ready to explore those legal twists and turns. What are the different ways a lease can come to an end?
Well, the most straightforward way is by the natural expiration of the lease term.
So,
The agreement has a set end date, and once that date arrives, the lease simply ends.
makes sense. But I'm guessing things aren't always that cut and dry. What are some other scenarios?
Sometimes both parties might decide to end the lease before its natural expiration.
Okay.
If they mutually agree to terminate the lease, they can do so in writing, effectively dissolving the contract.
Okay, so even if there's a set time period, there's always room for negotiation and early termination if both sides are on board.
Yeah.
What happens if one party isn't happy with the arrangement? Can they just walk away?
Not quite. That's where the concept of breach of contract comes into play.
Okay.
If either the lessor or the lessee violates the terms of the lease agreement, the other party has legal recourse.
Okay.
They can take steps to enforce the contract or even seek its termination.
So if a tenant consistently fails to pay rent or blatantly disregards the rules, the landlord has grounds to end the lease.
Exactly. And on the flip side, if the landlord fails to fulfill their obligations, like neglecting essential repairs or constantly disrupting the tenant's peace, the tenant might have grounds for legal action as well.
Got it. It's about holding both parties accountable to the agreed-upon terms. You mentioned earlier that the landlord has the right to regain possession of the property. How does that actually happen? What's the process?
That's where the concept of eviction comes in. If a tenant has violated the lease agreement and refuses to leave the property after proper notice, the landlord can pursue a legal eviction through the courts.
Okay, so eviction isn't something a landlord can just do on their own. It's a formal legal process. What does that process entail?
Eviction laws, they vary from state to state, but there are generally specific procedures that must be followed.
Right.
The landlord typically needs to file a formal eviction lawsuit with the court providing evidence of the lease violation and the steps they've taken to resolve the issue.
So it's not as simple as just changing the locks. It's a legal battle that plays out in court. What about the tenant's rights during this process? Do they have any legal recourse?
Absolutely. Tenants have the right to due process.
Okay.
They have the opportunity to present their case, challenge the eviction claims, and defend themselves in court.
Okay.
They can argue that the landlord hasn't followed proper procedures, that the lease violation wasn't as serious as claimed, or that they have a valid reason for their actions.
So it's not a one-sided process.
Okay.
The courts ensure that the tenant has a fair hearing and that their rights are protected. That's reassuring.
It is. Eviction should be a last resort, used only after all other attempts to resolve the issue have failed. Now let's move on to a fascinating concept that often comes up when leases expire, the idea of a tenant by holding over.
Tenant by holding over. That sounds intriguing. What's that all about?
Imagine a scenario where a lease has expired, but the tenant hasn't moved out and the landlord hasn't explicitly asked them to leave. Maybe they're still negotiating a new lease, or perhaps there's a delay in finding a new place.
Okay, so a bit of a gray area. The lease is technically over, but the tenant is still there with the landlord's, let's say, passive permission. What happens then?
The tenant status shifts from being a regular tenant under the original lease agreement to something called a tenant at sufferance, or a holdover tenant. Their legal standing changes even though there hasn't been a new agreement in writing.
So the original lease terms might not apply in full anymore.
Exactly. It can get a little complicated as the specifics can depend on state laws and the circumstances. For instance, the original fixed-term lease might convert to a month-to-month tenancy, or the rent amount might be adjusted based on market rates.
So both parties need to be aware that the legal landscape might have shifted, even though the occupancy continues. What happens if the landlord wants the holdover tenant to leave?
The landlord would still need to follow the proper eviction procedures.
Yep.
They can't just treat the holdover tenant as a trespasser. They need to provide formal notice and pursue legal action through the courts if the tenant refuses to vacate.
So this all highlights the importance of having a clear understanding of the legal framework surrounding leases. It's about protecting the rights of both parties and ensuring a fair and orderly process, even when unexpected situations arise.
You've hit the nail on the head. Whether you're a future landlord or a tenant or even a lawyer advising clients on these matters, a solid grasp of lease laws is crucial.
Absolutely. Now, before we wrap up this part of our deep dive, I want to touch upon a specific type of lease that we mentioned earlier, agricultural leases. Given their prevalence in India, are there any unique legal considerations that apply to them?
You're right. Agricultural leases are a significant part of the Indian economy, with a huge portion of our farmers relying on them to access land for cultivation.
Right.
And yes, they often have their own set of legal frameworks, which can vary from state to state.
Okay, so the rules of the game can change depending on where you are in India.
Right.
What are some of the key issues that crop up in agricultural leases?
One major concern is the protection of tenant farmers' rights, particularly regarding eviction and land use.
Okay.
There have been cases where tenant farmers have been unfairly evicted from land they've cultivated for generations, leading to economic hardship and social unrest.
Yeah, that sounds incredibly disruptive and unjust.
Yeah,
It's crucial to have legal safeguards in place to prevent such situations.
you're absolutely right. The legal framework needs to balance the rights of landowners with the security and livelihoods of tenant farmers. There are ongoing debates about strengthening tenancy rights, providing better compensation for improvements made to the land, and creating mechanisms for fair dispute resolution.
It sounds like a complex issue with deep social and economic implications woven into the legal fabric.
It certainly is. And it's a topic that deserves its own deep dive, which we might explore in a future episode. But for now, let's shift our focus back to more general lease scenarios and delve into some real-life examples that illustrate these legal principles in action.
Yes, I'm eager to see how these concepts play out in actual cases. Real-world examples always make the legal complexities more relatable and memorable.
Okay, let's start with a case that highlights the landlord's duty to disclose. Imagine a scenario where a landlord rents out an apartment knowing full well that the electrical wiring is faulty and poses a fire hazard.
Uh-oh. That sounds like a disaster waiting to happen.
It is. If the landlord fails to disclose this dangerous defect and a fire breaks out injuring the tenant, the landlord could face serious legal repercussions.
So the legal consequences go beyond just breach of contract. They could be held liable for actual harm caused by their negligence.
Exactly. Their failure to disclose a known hazard could be considered negligence, and they could be held liable for damages resulting from that negligence. Remember, the landlord has a duty to provide a safe and habitable environment for their tenants.
This makes the importance of documentation even clearer. If a tenant discovers a hidden defect that the landlord claims they were unaware of, how can they protect themselves?
That's where documentation becomes crucial.
Right.
Tenants should document any issues they discover as soon as possible, taking photos, videos, or even getting written assessments from professionals if needed. And most importantly, they should notify the landlord promptly in writing, keeping a record of all communications.
So creating a paper trail is essential in these situations.
It is.
It protects the tenant's interests and can serve as evidence if a legal dispute arises. What are some other common disputes that arise between landlords and tenants?
Another frequent area of contention is the tenant's right to quiet enjoyment.
Okay.
Let's say a landlord decides to undertake major renovations on the property without providing adequate notice or taking steps to minimize noise and disruption to the tenants.
Ugh, that would be a nightmare. Especially if you're trying to work from home or have young children trying to nap.
Exactly. Construction noise dust and general disruption can seriously interfere with the tenant's peaceful enjoyment of the property. And if the landlord fails to address the issue after being notified, the tenant might have grounds to pursue legal action.
So even if the landlord owns the property, they can't just disregard the tenant's right to a peaceful and undisturbed living environment.
That's right. The tenant is paying for the right to use and enjoy the property, and that includes protection from excessive noise and disruption caused by the landlord's actions.
It's a reminder that both parties have rights and responsibilities that need to be respected. Now, let's talk about a situation where the tenant might be the one at fault, specifically their duty to maintain the property. Where's the line between normal wear and tear and damage that the tenant is responsible for?
That's a question that comes up all the time.
Yeah.
Normal wear and tear refers to the natural deterioration of the property over time. Think about things like faded paint, slightly worn carpets, or minor scratches on appliances.
Okay, those things are bound to happen with regular use. It's just the natural aging process of a space.
Precisely. But damage goes beyond normal wear and tear.
Okay.
It's about actions or negligence that cause harm to the property beyond what's considered reasonable.
So if a tenant accidentally spills red wine on a white carpet and ruins it, that goes beyond normal wear and tear.
That's a perfect example.
Wow.
Or if they punch a hole in the wall during a fit of rage that's clearly damaged, that they would be responsible for repairing.
So it's about being a responsible occupant and taking reasonable care of the property. What if a tenant wants to make changes to the space? Can they just repaint or remodel as they please?
That's another area where the lease agreement is crucial. Most leases have clauses that restrict the tenant's ability to make alterations to the property without the landlord's consent.
Right. We talked earlier about how a tenant might not be allowed to make permanent changes without the landlord's approval. But what about smaller changes, like painting the walls a different color?
Even those seemingly minor changes can be a point of contention. Some landlords are very particular about the aesthetics of their property, and they might have specific rules about paint colors, wallpaper, or even the type of curtains allowed.
So communication is key. It's best to get the landlord's approval in writing before making any changes, even those that seem insignificant.
You're absolutely right. It prevents misunderstandings and potential disputes down the line. Now let's move on to a topic that's become increasingly relevant in recent years, subletting.
Yes, with the rise of platforms like Airbnb, more and more people are exploring the possibility of subletting their apartments or spare rooms to generate extra income.
Right.
But as we discussed earlier, there are legal considerations that come with subletting. What are the key things tenants should be aware of?
First and foremost, they need to check their lease agreement. Does it allow subletting? If it's silent on the matter or explicitly prohibits it, they can't sublet without the landlord's consent.
So yet again, reading the lease thoroughly is essential. What happens if a tenant sublets without permission?
It's considered a breach of contract, and the landlord might have grounds to terminate the lease. They could also pursue legal action to recover lost rent or damages caused by the subtenant. It's not a risk worth taking.
Okay, so let's say the lease does allow subletting. Does that mean the tenant is free to do whatever they want? Are there any limitations?
Even if subletting is permitted, it doesn't give the tenant carte blanche.
Okay.
They still have responsibilities to the landlord.
Okay.
For example, they need to ensure that the subtenant complies with all the terms of the original lease agreement.
So if the subtenant throws wild parties, damages the property, or fails to pay rent, the original tenant is still on the hook.
That's right. The landlord can hold the original tenant accountable for any breaches of the lease, even if those breaches are committed by the subtenant.
Wow, that's a big responsibility. I can see why landlords might be hesitant to allow subletting.
It's understandable. That's why it's crucial for tenants to be extremely diligent if they're considering subletting. They should carefully screen potential subtenants, have a clear written agreement in place that outlines the terms and conditions, and make sure the subtenant understands and agrees to abide by the original lease terms.
Those are all excellent tips. It sounds like subletting can be a minefield if not handled carefully and legally.
It definitely can. It's an area where seeking legal advice is often a wise move, both for landlords and tenants.
Excellent point.
Yeah.
Well, we've covered a lot of ground today, from the basic definition of a lease to the nuances of different lease types, the rights and liabilities of both parties, and even the complexities of eviction and subletting.
We've really delved into the legal intricacies of leases, and I hope you're starting to see how these concepts play out in real-world scenarios.
Absolutely. And through these examples, we've highlighted the importance of having a clear lease agreement, understanding your rights and responsibilities, and seeking legal guidance when needed.
Those are key takeaways for anyone involved in leasing, whether they're a landlord, a tenant, or a future legal professional advising clients on these matters.
Well, I'm eager to hear more about how these legal principles have been applied and interpreted in actual court cases.
Okay. Let's shift our focus to some landmark legal cases that have shaped the way we understand lease laws in India.
No.
These cases provide valuable insights into how judges have applied the law to specific situations, setting precedents that guide future legal decisions.
That sounds fascinating.
Oh,
I'm ready to explore the legal precedents that have shaped this area of law. Where do we begin? Welcome back to LexTalks. We've explored the ins and outs of lease law, delved into real-world scenarios, and even examined some landmark cases. Now let's shift gears a bit
yeah.
and equip ourselves with some practical knowledge.
Yes, let's distill all this information into actionable advice because whether you're a landlord, a tenant, or a future legal eagle advising clients on these matters,
Right?
having practical tips in your arsenal is crucial.
Absolutely. So where do we begin? What's the most fundamental piece of advice you would give to someone who's about to enter into a lease agreement?
Without a doubt, the most important thing is to read the lease agreement carefully. I mean, really read it, not just skim through it. Understand every single clause, every term, every condition.
I can't stress that enough. It sounds obvious, but so many disputes arise simply because one or both parties didn't fully grasp what they were agreeing to. What are some specific things people should be looking out for when they're scrutinizing a lease agreement?
Pay close attention to the key elements we discussed earlier. The names of the parties, a clear description of the property, the duration of the lease, the rent amount, and the terms for renewal or termination.
Right, those are the foundational pieces of the agreement.
Yeah.
But what about those less obvious clauses that often trip people up?
Exactly. Look for clauses that address repairs and maintenance, who's responsible for what. Pay attention to restrictions on subletting alterations to the property and the landlord's right of entry. These are often areas where disputes arise, so clarity is essential.
And if something isn't clear or seems unfair, what should people do?
Don't be afraid to ask questions. If you're a tenant, clarify any doubts with the landlord before you sign anything. If you're a landlord, be prepared to answer your tenant's questions thoroughly and transparently.
Open communication can prevent so many headaches down the road. It's much better to have those potentially awkward conversations up front than to end up in a legal battle later on.
Absolutely. And if you're still unsure about certain clauses or, the implications of the agreement, seeking legal advice is always a wise move.
Especially if it's like a commercial lease or a long-term residential lease with significant financial implications. It's worth the investment to have a legal expert review the agreement and make sure your interests are protected.
I couldn't agree more. Now let's talk about documentation. We touched upon this earlier,
Yes.
but it's so crucial that it bears repeating. Document everything.
I love that you're emphasizing this point. It's something that often gets overlooked, but it can be a lifesaver in a dispute.
It really can. Keep a record of all communications with the other party, whether it's emails, letters, text messages, or even notes from phone conversations. Document any repairs or maintenance issues, taking photos and videos as evidence.
That paper trail can be incredibly valuable if you need to prove a point or defend yourself in a legal dispute. It's much harder to argue against hard evidence.
Exactly. Now let's move on to some practical tips for handling disputes. What's the first step someone should take if a disagreement arises with the other party?
I imagine the best approach is to try to resolve it amicably, before things escalate. Communication is key, right?
You're absolutely right. Try to have an open and honest conversation with the other party, expressing your concerns and listening to their perspective. Sometimes misunderstandings can be cleared up with a simple conversation.
And if that doesn't work, what are the next steps?
If the issue is more serious or if communication breaks down, consider sending a formal written notice outlining your grievance and the steps you'd like the other party to take to resolve it.
So putting it in writing creates a more formal record of the issue and the attempts to address it. What if that still doesn't lead to a resolution?
At that point, you might consider mediation.
Okay.
This involves bringing in a neutral third party to help facilitate a conversation and guide you towards a mutually agreeable solution.
Mediation can be a great way to de-escalate a conflict and find common ground without resorting to a costly and time-consuming legal battle.
It is. And if all else fails and you feel your rights have been violated, seeking legal counsel is the next logical step. A lawyer can advise you on your legal options, help you understand the relevant laws and precedents, and represent your interests in court if necessary.
Knowing when to consult a legal professional is essential. It can save you a lot of stress and potentially costly mistakes. Now let's talk about something we touched upon earlier, the future of lease laws in India. How do you see these laws evolving to keep pace with societal changes and emerging trends?
That's a great question. Lease law is a very dynamic area that's constantly adapting to new challenges and technological advancements. One trend we're seeing is the rise of short-term rentals and the sharing economy fueled by platforms like Airbnb.
Right. This is an area where traditional lease laws are being tested and stretched. What are some of the potential legal developments that you foresee in this area?
I think we'll see more clarity emerging around the legal status of short-term rentals and the rights and responsibilities of platforms like Airbnb. We might see specific regulations or amendments to existing laws that address the unique challenges posed by this new model of renting.
So striking a balance between innovation and consumer protection.
Exactly.
What about the broader trends of urbanization and the increasing demand for rental housing in India? How do you envision lease laws evolving to address these challenges?
I think we'll see a push for greater clarity and transparency in lease agreements, making them more user-friendly and accessible to both landlords and tenants. We might see standardized lease templates or online resources that simplify the process and reduce the potential for disputes.
That would be incredibly helpful, especially for first-time renters or those unfamiliar with all the legal jargon. What about the issue of affordability and security of tenure for tenants? Do you see any potential legal reforms in that direction?
That's a really pressing issue, especially in cities with high rent burdens. We might see further development of rent control mechanisms or legislation that provides greater security of tenure for tenants, striking a balance between the interests of landlords and the need to protect vulnerable renters.
It sounds like lease law is poised for some really interesting developments in the years to come. It'll be fascinating to see how it adapts to the changing needs and dynamics of our society.
Absolutely. And as future legal professionals, you'll be at the forefront of these changes, shaping the legal landscape and ensuring that lease laws are fair, equitable, and responsive to the challenges of our time.
Well, this deep dive into lease laws has been incredibly insightful. We've explored the fundamental principles, analyzed real-world scenarios, examined landmark cases, and even peered into the future of this dynamic area of law.
We've covered a lot of ground, and I hope you've gained a deeper understanding of this complex yet fascinating area of law.
I know I have, and I'm sure our listeners have as well. Before we wrap up, do you have any final words of wisdom for our audience?
Whether you're a landlord, a tenant, or a future lawyer, remember that knowledge is power. Arm yourself with information, understand your rights and responsibilities, and don't hesitate to seek expert legal advice when needed.
Excellent advice. Well, thank you for joining us on this deep dive into lease laws in India. It's been a pleasure exploring this topic with you.
The pleasure was all mine.
And to our listeners, thank you for tuning into LexTalks. We hope you found this episode informative and empowering. Thanks for joining LexTalks. Subscribe for more legal discussions.